If an estate in Wisconsin is worth more than $50,000, do you need to go through probate? Let's find out. Hello, I'm Gina Newell with eXp Realty in the Madison, Wisconsin area. I offer my knowledge and expertise as a certified real estate probate specialist. I have personally gone through this process, but I am not an attorney and I'm not giving you legal advice. If you have lost someone, I wish you comfort and peace. In Wisconsin, any estate worth more than $50,000 must go through probate except when the asset is in the name of the trust, is jointly owned by a survivor, or is payable or transferable upon death. If an estate is less than $50,000, an heir can transfer the decedent's assets by affidavit. There are other assets that don't need to go through probate because of already named beneficiaries, and they are retirement accounts, distributions from a pension plan, or household items or goods of minimal value. There are two main types of probate, informal and formal. Every Wisconsin county has a probate court registrar who will give you a packet of forms and the instructions. You need to obtain these forms in the county where the decedent passed. In Wisconsin, instead of an executor, we call them a personal representative. This personal representative has a number of very important duties. But even if a personal representative is named in the will, you need to be appointed by the probate court before you can assume any legal duties. But sometimes the hardest duty of the personal representative is to safeguard the estate and establish guidelines on how to distribute the decedent's assets. So, before you file for informal probate, you should obtain copies of the death certificate and inform interested parties, such as the banks or retirement accounts or Social Security, Department of Motor Vehicles, any memberships, subscriptions, and the like. You should probably contact the three credit reporting agencies for a list of creditors and inform them not to approve any new credit applications. After you assess the decedent's records, you need to complete an inventory and an accounting of the decedent's assets and debts. So, how do you start the informal probate process? You need to file an application for informal administration with the probate court registrar, and that includes filling out the various forms and attaching the will if there is one. You will need to provide a list of the heirs with their contact information, their consent to informal administration, and your consent to serve as the personal representative. After you submit the application, domiciliary letters will be mailed to you that designates you as the personal representative on behalf of this state. Now you're ready to perform your legal duties. You also need to publish a notice to creditors in the newspaper. Can the personal representative sell the real estate during probate? Yes, with proper documentation. The personal representative would need to get the property appraised and get an assessment based upon the date of death. It is also a good idea to get a home inspection done prior to listing. As your realtor, I would set up a plan of action for preparing the house for sale and discussing your listing options. Because the net sales price cannot be lower than a certain percentage of the appraised price or fair market value based on the comps. To settle the estate, all the assets, including real estate, must be properly disposed of and the proceeds received by the designated parties. I feel my role is to explain options and mediate when appropriate. Grief can be difficult for some people and can be manifested in multiple ways. My intent is to go through this process with empathy, compassion, and closure. So let's discuss how I can be of help to you and answer any questions you may have. I've included a probate report down below that you can download, and perhaps we can discuss if you have further questions. Thanks so much for watching.